Hello and welcome to Our American States, a podcast from the National Conference of State Legislatures. This podcast is all about legislatures, the people in them, the policies, process, and politics that shape them. I'm your host, Ed Smith.
We play a critical role in protecting investors, large and small, from investment fraud and abuse.
That was Melanie Center-Lubin, the Securities Commissioner in Maryland and president of the North American Securities Administrators Association. She's one of my guests on the podcast. Our focus in this podcast is state securities administrators. These are the agencies in every state that oversee investor protection and efficient capital formation. Their key focus is protecting consumers who purchase investment advice or securities. Also on the podcast is Faith Anderson, the Chief of Registration and Regulatory Affairs of the Securities Division of the Washington State Department of Financial Institutions. They discuss the various roles state securities regulators play, the assistance they can often offer state legislators and legislative staff, and how state regulators work with their federal counterparts. They also sketched out their perspective on a variety of policy topics, including licensing and digital currency. Both Lubin and Anderson also wanted legislators to know that the securities regulators in your state are always available to answer questions for you or your constituents. Here's our discussion. Melanie, Faith, welcome to the podcast. Thanks to both of you for coming on to talk about state securities regulators. Now, I'll confess, when I started working on this podcast, I knew just a bit about state securities regulators, and I think I know a fair amount about state government. So let's start there, Melanie. What's the role of state securities regulators, and how much does the role differ from state to state?
There's all kinds of things state securities regulators do, and I'm not surprised that you might not know about us all that much. But we play a critical role in protecting investors, large and small, from investment fraud and abuse. State securities regulators are responsible for the licensing of firms and investment professionals, registration of some securities offerings, branch office sales practice audits, investor education, and most importantly, the enforcement of state securities laws. Because many of the issues facing each state are different, each has differing laws and regulations protecting investors in their jurisdictions. The vast majority of our laws are based on the Uniform Securities Act, and it's important to know that the focus of state securities regulators is to keep all investors, including older investors or investors with diminishing capacity, safe from financial abuse. As you mentioned, I'm the Securities Commissioner in Maryland, and our state has securities regulations specific to the need of Marylanders, but each state is in an island, and very frequently the needs of investors in one state are very similar to the needs of investors in other jurisdictions. All states, as well as the provinces and territories of Canada and the country of Mexico, are members of the North American Securities Administrators Association, or NASA, like the space folks with an extra A at the end. NASA regularly brings together each territory, state, and province to discuss investor protection trends, enforcement of our laws, capital formation issues, and regulation needs that could affect investment advisors and investment advisor representatives, broker-dealers and their representatives. Most people know them as stockbrokers and the firms they work for, securities issuers and franchise owners, as well as many other issues that affect state securities regulation. From my perspective, each jurisdiction is stronger when working together to help facilitate legislation that better protects investors. Again, the primary goal has always been and will remain to advocate and act for the protection of investors, especially those who might lack experience, education, or resources to protect their own financial interests. NASA member states are driven by the conviction that every investor deserves protection and that the welfare of investors must not be sacrificed in the process of capital formation.
Much of our audience is state legislators and legislative staff, and I wonder if you could talk a bit about how securities regulators work with the legislature.
There are some similarities and some differences across the 50 state securities regulators. To some degree, the nature of the working relationship between them and their state legislature turns on first, where the regulators are situated within the state's government, and second, applicable rules and processes related to their legislation, and third, everybody's boss's preference with how you relate to the legislature. But one similarity is that we all hope to serve as a source of technical expertise regarding any future or pending state legislation that would or may affect state securities regulators or state securities regulation. I spend hours and hours and hours with pre-files and our legislative session seeing what's out there to see, is there a purposeful or, more importantly, an inadvertent effect on the Securities Act or any of the other statutes we enforce. If legislative staff needs expertise, historical insights, legislative testimony, or anything like that, they really should consider contacting their state securities regulator at the earliest possible point in the whole policy-making process. Also, if the staff is trying to identify people to serve on public policy councils or commissions, they should keep their state securities regulators in mind. And if you don't know how to get in touch with state securities regulators, go to NASA's website, which is at www.nasaa.org. Click on the Contact Your Regulator button in the upper right-hand corner of the website's main page and navigate to your jurisdiction. Click on that and you'll find the information about how to get in touch with your local regulator. Now, about the differences in how we engage with state legislators, I learned early in my 35-year career as a state securities regulator to be careful about talking about the approaches of my peer regulators because things differ from jurisdiction to jurisdiction. So we all prefer to describe our own offices. So I can talk a bit about Maryland and then turn it over to Faith to talk a bit about her office in Washington State. So Maryland's a little bit different. We're one of 5 securities divisions that's housed in the State Attorney General's office. But we've got regulators can be all over the place. Some are in financial services, regulatory agencies. Some are that may house banking and insurance, house all 3 of us, house 1 or 2. We could be in the Secretary of State's office. We could be in the state auditor's office. They're just different, or we could be freestanding offices in and of itself. So it could be in all kinds of different places. In Maryland, because we're part of the AG's office, we coordinate with the rest of the AG's legislative agenda, but we also raise proposals to members, together with members of our General Assembly, and that frequently arises because our legislators have an interest in the area and they pay attention to model legislation or regulations that are developed through NASA. So we're often called upon to help legislators and legislative staff with legislation they're contemplating, or we reach out to them directly, as I said before, if I see pending legislation that might affect something going on in our office or something that we have an interest in for another reason. So as an example, when NASA developed the model legislation to protect seniors and vulnerable adults from financial exploitation, we worked with Maryland legislators in both houses on a bill that would not only adopt that legislation, but would also add or amend other provisions of the Securities Act that helped industry with compliance with certain provisions that had become difficult or had changed because federal law had changed. And we also were able to work into that bill some other changes that help our office with our compliance enforcement and investor protection efforts. We've also been able to help legislators with other bills that they were proposing and made sure that those provisions accomplished what they wanted to accomplish and weren't inconsistent with other provisions in the statute that might have created unintended consequences for that legislation. So things like that came up when we were working on a model senior designation provisions from NASA model legislation that had been proposed in Maryland. And we made sure that already worked with some similar provisions that we already had in the statute and wouldn't run contrary to other things that we had either in our statute or our regulations. So as I had mentioned before, it's different in different states, and maybe Faith can talk a little bit about how it works in Washington State.
Yeah, Faith, why don't you explain how it works in Washington?
My team sits within Washington State's Department of Financial Institutions, or DFI for short. DFI has 4 regulatory divisions that regulate a wide range of financial enterprises and individuals, such as our state-chartered banks, state-chartered credit unions, mortgage brokers, payday lenders, and securities issuers and salespeople. DFI is a cabinet agency of state government with our director appointed by our governor. Under Washington law, public funds generally may not be used for the lobbying of state legislators by state agencies. However, this does not prevent officers or employees of an agency from communicating with a member of the legislature on the request of that member, or communicating to the legislature through the proper official channels requests for legislative action or appropriations that are deemed necessary for the efficient conduct of the public business are actually made in the proper performance of their official duties. Our agency collaborates with the Office of Financial Management, an office within the Office of the Governor, concerning draft or pending legislation and our operating budget. Any legislation our agency requests from the legislature must have the prior approval of this office. We provide information to legislative members as well to inform legislation under consideration. In a limited number of situations, we may support or oppose legislation, but for the most part, we remain neutral. One example of our engagement with legislators concerned our state crowdfunding legislation that was passed in 2014. We provided legislators with information about the legislation that was under consideration, and we also provided suggestions for how to improve the legislation from an investor protection standpoint. Another example is from 2020, where we successfully requested legislation to repeal Washington's Debenture Company Act. This was an act that imposed safety and soundness measures on certain issuers of debt securities. We determined that that legislation had become obsolete, requested that it be repealed, and we were successful.
So it sounds like a lot of the role vis-a-vis the legislature is offering your expertise. Melanie, I'm wondering if you could explain the relationship between state securities regulators and federal securities regulators.
It's a really good question because your listeners probably don't know this. I don't think most people know this, but state securities regulation predates federal securities regulation. NASA was founded in 1919 with the first state securities laws adopted in 1909. And then Congress didn't create the SEC until 1934 and actually used the state law as a model for what was put into the Securities Act of 1933.
Well, we all know that states are where things get done, so I'm not too surprised by that.
During the last 88 years, the federal government, unfortunately, has chipped away at the authority of state securities regulators to protect investors and promote capital formation. So my colleagues and I have opposed many of those changes because we believe protecting investors is a significant challenge, and no single regulatory agency can really do it by themselves. To that point, and notwithstanding the efforts by our federal counterparts to restrict our authority, we've continued to try and partner with the SEC and other federal partners on everything from investor education to examination to enforcement. And we also coordinate our rules with their rules because we either have overlapping jurisdiction in a lot of spaces or jurisdiction where someone might start out as a state level advisor or a state level issuer and then eventually have to coordinate with federal laws. So we try to keep the requirements consistent. By way of an example, with working with the SEC on enforcement, this past February, NASA and the SEC announced a major enforcement action with a joint $100 million settlement with a company called BlockFi Lending LLC. And that case involved BlockFi's lending products and practices. And a majority of the state securities regulators agreed to the term of the settlement with BlockFi to resolve its past unregistered activities, and more states are expected to follow.
Now that you've given us some notion of how state securities regulators work, I wonder if we could talk about some of the key issues of concern to NASA and state regulators generally. I'd like to hear from both of you on this. Melanie, why don't you start?
NASA's got a very robust policy agenda, and I'll provide two highlights and then turn it over to Faith to talk about, key issues that NASA State Legislation Committee that she serves on is working on. First, at NASA, we continue to devote a lot of time and resources to making sure that government enforces regulation best interests. So for your listeners who don't know it, the SEC's regulation best interest, which is also called Reg BI, establishes a best interest standard of conduct for broker-dealers and their associated persons. Again, those are the stockbrokers and the firms they work for. What Reg BI requires is oversight and that they act in the client's best interest when they make a recommendation to a retail customer of any securities transaction or investment strategy that involves securities. And that also includes making recommendations of the types of accounts customers ought to open or have. Late last year, NASA published the results of a nationwide survey that state securities regulators conducted that provided the first comprehensive look at broker-dealer industry policies and practices following the implementation of Reg BI. We had done a survey before the regulation went into place to try and see what was the baseline with the firms about their practices, and then we did a follow-up to see what's changed. The survey showed that there were some improvements, but most firms were operating in the same manner as they had prior to the SEC's adoption of Reg BI, especially in the area of harmful compensation conflicts. We're continuing to engage with senior SEC staff about opportunities to strengthen the enforcement of Reg BI. It's a really important rule, and we're also working on getting the word out to industry about where we see problems and working now on a follow-up examinations to go see, what have the firms actually done on site and how have they come into compliance with Reg BI. Another area where NASA's devoted significant resources is protecting older and sometimes vulnerable investors. As many of your listeners know, we and other state government actors have played a leadership role in the decades-long fight to protect these investors. Our work in the area draws on all our areas of expertise, including investor education, policymaking, examination, and where it's appropriate, enforcement work. And at the state and federal level, we've both been proactive and reactive. By way of an example, and we brought this statute up already, in 2016, we finalized a model act called NASA's Model Act to protect vulnerable adults from financial exploitation. The Model Act gives industry participants and state regulators tools to help us all detect and prevent the financial exploitation of vulnerable adults. So the Act mandates reporting to a state securities regulator and state adult protective services agencies when a qualified individual has a reasonable belief that financial exploitation of an eligible adult has been attempted or has occurred. The Act also allows the financial services firm to disclose to third parties in instances where there's someone designated who can receive the disclosure that there could be a problem. And beyond that, the Act directs that disclosures can't be made to a third party who is the suspected abuser or the person who might be conducting the financial exploitation. So since that model legislation was passed by NASA, at least 34 states have passed legislation based in whole or in part on that Model Act. And thanks to Faith's hard work and other members of NASA's State Legislation Committee and NASA's Senior Issues and Diminished Capacity Committee, we've gotten significant uptake, and other states are also considering adopting those provisions. Now, at the federal level, we've continued to advocate for the passage of S 3529, which is called the Empowering States to Protect Seniors from Bad Actors Act. It's bicameral, bipartisan legislation, which the House passed in May 2022, and it would establish a grant program at the SEC to enhance existing efforts by state securities and insurance regulators to protect senior investors and policyholders from financial fraud. Lastly, we continue to work with a diverse group of partners, including AARP, the SEC, the Consumer Financial Protection Bureau, FINRA, and a whole lot of other groups to spread the word about the resources we have that we've set up as a service to the securities industry on how financial professionals can detect and prevent potential elder financial exploitation, how others who deal with seniors and potentially vulnerable adults can detect it, and ways that they can get in touch with us, how they follow provisions of the law, investor education material to help people detect and prevent this, and it goes on and on. So those are just two of NASA priority areas, and Faith can talk a little bit more about some of the other areas.
Melanie, thanks. We're going to take a quick break and come back with the rest of our discussion.
This year's NCSL Legislative Summit brings you a terrific lineup of speakers that you won't want to miss, including Kevin O'Leary, fresh out of the Shark Tank, 5-time Olympic gold medalist Missy Franklin, 2-time world champion adventure racer and San Diego firefighter Robin Benincasa, founder of the Cook Political Report, Charlie Cook, the director of the U.S. Census Bureau, Robert Santos, astronaut Matthew Dominic, who will discuss NASA's new moon mission, the Artemis Project, author of Molly's Game, Molly Bloom, former Major League manager Clint Hurdle, famed storyteller Donna Washington, and a profound session on the Christmas truce of 1914 during World War I, presented by Kurt Stedron. Don't miss meeting these and other exciting speakers at the summit, which takes place August 1st through the 3rd. Register now at www.ncsl.org/summit. That's www.ncsl.org/summit.
I'm back with Melanie Center-Lubin, the Securities Commissioner in Maryland and President of the North American Securities Administrators Association. Also with me is Faith Anderson with the Securities Division of the Washington State Department of Financial Institutions. Faith, Melanie was just talking about policy priorities, and I wonder about your perspective. I'd be particularly interested in your thoughts in the area of occupational licensing.
Well, I can talk about the work of the State Legislation Committee in particular. During the last 2 years, we have devoted significant time and resources to improving government policy in the areas of whistleblower protection, investor compensation, and professional licensing. I can start with the professional licensing bills. Last year, we reviewed various bills that were pending in state legislatures that would limit the discretion of state securities regulators, to review applications of financial professionals, including those from individuals with criminal convictions. So unless amended, these bills would prevent state securities regulators from denying applications by individuals convicted of plainly disqualifying conduct, such as securities fraud, forgery, theft, or embezzlement. Such a result would be contrary to the investor protection role that we play as state securities regulators, that role that we have carried out for decades. So following the review of those state laws, the state bills that were pending, we wrote to NCSL in April 2021 to raise awareness of these bills, and we included some model legislative language to address the issue in our letter. If state legislative staff haven't had an opportunity to review that letter, I would encourage them to review it and seek counsel from their own state securities regulators. The letter is on NASA's website, and I believe it is also included in the podcast materials. Wasn't sure if you wanted me to talk about our Model Whistleblower Award and Protection Act.
Yes, why don't you talk about the whistleblower policy?
Yeah, so this is a model act that NASA passed in 2020. The formal title of the act is NASA Model Whistleblower Award and Protection Act. As its name suggests, this model act provides a state securities regulator with authority to make monetary awards to whistleblowers, and it also establishes protections against retaliation by employers. We drew from the whistleblower award provisions that were contained in Section 922 of the Dodd-Frank Wall Street Reform and Consumer Protection Act that was passed in 2010. We also drew from the SEC's rules they adopted thereunder in Regulation 21F and whistleblower laws that had previously been enacted in Indiana and Utah. Depending on the jurisdiction, the act can either be adopted as legislation during a regular legislative session or implemented by regulation.
I think another area our audience would be interested in is the regulation of cryptocurrency and digital assets generally. There's been a lot of attention to that sector recently because of some wide fluctuations in the market. In fact, NCSL is planning a session on the topic at the upcoming legislative summit in early August. I'm wondering what the role of state regulators is in this emerging space.
I think that's a great question, Ed, and I'll do my best to give you a quick answer. When digital assets emerged over a decade ago, state securities regulators just expanded the portfolio of work that we do to educate engage, examine, and if appropriate, enforce the laws. So I'll give you a few examples of our work. During the last 10 years, we have published at least 4 to 5 investor advisories regarding digital assets and associated technologies. And all of those are, like the other materials, available on NASA's website at nasaa.org. In addition, we engaged with peer regulators and the industry through formal and informal meetings. NASA has a FinTech committee. That's another board level committee, and they have spearheaded some of that work. In 2018, NASA organized a task force of its member regulators to conduct coordinated investigations of alleged violations. This was called Operation Crypto Sweep. This effort generated a first of its kind enforcement action by state regulators across the country. And last, and perhaps most on point for this audience, we recently published NASA's core principles for evaluating state legislation relating to digital assets. In a nutshell, our core principles set forth NASA's vision for policymaking in this area. We believe that we should be, number one, encouraging registration and compliance within the securities regulatory framework. 2, fostering better regulatory coordination, particularly between state regulators, the SEC, and the CFTC. And finally, encouraging informed, goal-oriented investment decision-making in our capital markets.
Well, that's some very specific information that I think our audience can use. As we wrap up, I'd like to return to a basic question for both of you. Do you see your role as balancing regulation while at the same time encouraging capital formation? And how do you talk to legislators about that? Faith, why don't you go first?
The quick answer is that I don't view myself as balancing anything. To take a step back, we've had a securities regulatory framework in the United States for over 100 years now, as Melanie pointed out earlier. This framework has long facilitated capital formation and associated innovations. Examples include changes in investment products, communication platforms, and business models that governments, businesses, and people have used, and in many cases still use. A key component of a regulatory framework is something called registration. What is registration? In the United States, and I'm oversimplifying here a bit, we require participants in our capital markets, such as broker-dealers and investment advisors, to register themselves as well as their activities, products, and professionals with the government. Registration helps to ensure that people with capital, that is investors, receive important information from a person or entity who might not otherwise provide relevant information. Registration also allows regulators like me to examine the activities, entities, products, and professionals for compliance with various laws and rules designed to make our capital markets operate in a fair, orderly, and efficient manner. So going back to your question, Ed, I view our securities regulatory framework as the primary reason entrepreneurs and investors have continued to use our capital markets time and again over the last 100 years. In my office, I'm not the primary point of contact for engaging directly with state legislators. However, I know my colleagues would echo a similar message to state and federal legislators.
And Melanie, what's your perspective on that? You get the last word here.
Thanks. And before I miss the opportunity to say so, we really appreciate you inviting NASA to participate in this podcast episode. If anybody needs additional information, go to the website. You can figure out how to reach us or reach our corporate office, and they could direct you to the appropriate state. Or if you have a question, that's at the state level, or talk to you or directly the appropriate person to talk to about any of the things we've talked about. So my final thoughts, I've been a state securities regulator, not to date myself, but I will, for over 35 years. If I've learned anything, it's that it really takes a village to protect investors, to foster capital formation, and to support inclusion and innovation in our capital markets. I can't emphasize enough that state legislators and their staff should seek early input on any proposals that would or might affect state securities regulators or state securities laws. We can help you and your staff understand how your idea would or wouldn't affect, a very well-established regulatory framework. both, in the U.S. at the state level and also at the federal level, how it'll affect supporting investor protection, how it'll affect supporting responsible capital formation. Also, depending on the nature of the idea, and lots of people have great ideas, it might be something that we want to tell other state securities regulators about so they could look at adopting it in their own jurisdictions and be able to, pursue the same or a similar policy for their state. So again, Ed, thanks so much for inviting us on today, and we're available if anybody needs any follow-up.
Well, thanks to both of you. I think those in our audience, and certainly myself, know a lot more about state securities regulators than when we started. Thanks for educating us. Take care. And that concludes this episode of our podcast. We encourage you to review and rate NCSL podcasts on Apple Podcasts, Google Play, Pocket Casts, Stitcher, or Spotify. We also encourage you to check out our other podcasts, Legislatures, The Inside Story, and the special series, Building Democracy. Thanks for listening.